Welcome to the program. I'm Marty Schenkman, and I'm joined by two colleagues, Jonathan Blotmacher and David Ritter. And we're going to talk about a topic I honestly had never really thought that I'd have to want to understand, but we do. And that's the new FTC rule banning non-competes. And we're going to try to be very practical, not just explain some of the rule, but give you some practical guidance on how it may impact estate planning. And Jonathan and I have a real lawyer joining us, David Ritter from Brock Eichler, who's going to enlighten us from the corporate and employment law perspective, which is absolutely essential to this topic. And Jonathan and I are going to try to emphasize why this is so important for estate planners to know. Obviously, people like David who do corporate and employment law have to know and deal with this. But we estate planners cannot ignore it, and it could have, for some clients, not all, but for some clients, really profound implications. And we're going to talk about that. Before we get started, the PowerPoints are available on the console. If you miss it, Interactive Legal, I believe Peak Trust as well, our two sponsors, and my firm, Schenken Law, will post the recording and materials to our websites. And we do not give out formal CLE or CPE, but you will get from the system a certificate in case you can self-report. The best thing to do if you have questions is to email us directly. David, just in case I forgot, if I didn't put your email, I think I did, just tell everyone your email real quick and then they'll have it.
Sure, it's DX as in Xavier, Ritter, RITTER, at brockeichler.com.
And if it's a tough corporate or employment law question, send it to David or Jonathan, not me. Now, our two sponsors, first is our favorite drafting software company, Interactive Legal. And we have Vanessa to tell us about Interactive Legal.
Well, hi, everyone. Thank you, Marty, for that introduction. I'm Vanessa Kanega. I'm the CEO of Interactive Legal, which, as Marty alluded to, provides drafting software and other educational and other resources for estate planning and elder law attorneys. So you can find out more information about us and what we do at interactivelegal.com or by emailing our sales team, our wonderful sales team, at the email address you see on your screen right there. We're happy to answer any questions. You will also find a webinar library, including other Schenkman law webinars and other webinars that we've put on our website. So please check out the educational resources we have there. Most of them are available to the public if you just put in some information. So we are very proud to sponsor this and other webinars that Marty and Jonathan and others have put on throughout the years. And looking forward to this one. It's a topic that I frankly didn't even consider the impact on estate planning. So it just goes to show the value of these webinars. So thanks very much, Marty, Jonathan, and David for presenting on this topic, and we'll look forward to it.
Let me add a stronger plug than Vanessa gave for ILS. If you are drafting documents using template forms rather than document generation software, with 2026 coming down the pike, by the end of 2025, everyone that knows the word estate or will or trust is going to be inundated with work. Look at transitioning into document generation software as soon as possible, because it will revolutionize, and I don't think that's an overstatement, how you draft. And with the deluge we're all going to face of pre-2026 or before the end of 2025, which makes it sound even sooner, planning, you really want to migrate to document generation software. You'll be more efficient, less prone to make errors, and be able to deal with that wave coming. Jonathan,
we will help you set up custom
we weren't able to be joined today by somebody from Peak. Jonathan, Andre couldn't make it. Perhaps you can make a plug for Peak.
Yeah, well, Marty, as you know, I've been involved with Peak Trust Company since its inception, since it was built upon the laws that I had recommended to the state of Alaska and which were passed, which, among other things, brought domestic asset protection trust to the United States. I have used Peak not just because relatives of mine have been involved with Peak since its inception. I've referred hundreds of clients to Peak, and as far as I know, not one has left that institution. It's a really great small trust company, and I'm now employed by them as well. And if you want really hands-on, dedicated services for trust matters, I'd suggest you talk to the folks at Peak.
Quick comment. Again, planning for pre-2025, working with an administrative trust company, and Peak is our sponsor, so we'll use their name, but there's others, can be incredibly valuable to get situs in a trust-friendly jurisdiction, which I think is critical. One of the things that is not a SLAT webinar, I like to put SLATs in different trust-friendly, DAPT-friendly jurisdictions for a whole variety of reasons. And Peak has been incredibly responsive for scores and scores of client matters. And that's certainly something, if you have not worked with an administrative trust company on a regular basis in one of the trust-friendly jurisdictions. Jonathan, I think there's now 20 states Wisconsin got on board that have DAP legislation, or is it more than 20?
Yeah, it's got to be at least that, because Wisconsin has come on. In fact, folks at Wisconsin called me to ask me for my advice and to support what they were doing. And of course, I'm completely in favor of it. Just because you have a good asset protection state isn't the whole answer. You'll also want to consider whether or not the laws of that state otherwise are friendly. And you're also going to want to know whether or not you can avoid state income tax. At least one state, Louisiana, says if you have a trust governed by Louisiana law, it's subject to Louisiana income tax. Obviously, you wouldn't want to create your trust there. But and Louisiana, I don't think now has asset protection trust legislation, but it's a critical factor, really worth your thinking about when you have your client create a trust. You just don't want to default to your home state. You want to see what other options are available.
And if you want to know more about that, you're going to just have to wait for Jonathan and I to do a pre-2025 planning lecture, which we have in the hopper. And we're going to try to do that soon. So let's dig into this. David, do you want to give us a quick overview of what this is all about? And then I will, with Jonathan, explain why estate planners need to pay attention to this topic.
Sure. And thank you, Marty, and thank you, Jonathan, for having me. And so just to try to give a quick overview so that we can get back to Marty and Jonathan addressing the estate planning consequences. Essentially, there are a few different types of restrictions that have become popular for trying to protect a company's business. And this goes whether it's a very large company or a closely held company, which in the estate planning area, there might be a lot of family-owned, closely held businesses where this could be applicable. And essentially, you want to try to protect your business from employees being able to open up competing businesses. And some of the main restrictions, one is a non-compete. I'd say confidentiality and non-solicitation also. But this is mainly addressing the non-compete and other functional non-competes, which we might get into more later. It's essentially making it so that a non-competition covenant can no longer be enforced. And what a non-competition covenant usually is that someone can't open up a competing business within a certain area and for a certain number of years after having been an employee of your company. And it very clearly has just this rule eliminates the ability to do that. Certain high-level, high executive employees, if they have existing non-competes, they're grandfathered in. But other than that, even going forward for any employee, regardless of their level or their compensation, you can no longer can restrict them with a non-compete.
And David, isn't it so that it's not just starting a competing business, but it's going to work for a competitor as well, correct?
Yes. Sorry. Yes. Thank you, John. Yes. Sorry. That's a very good point. It's not just starting your own business. It's working for anyone who's competing, whether you're doing it as an owner, an employee, even an independent contractor. It could be any competing business that was often restricted in this non-compete, and that's something that companies are not going to be able to include for employees anymore or independent contractors.
And David, what surprised me in part about this is usually federal laws and even state laws focus on large companies. So, you have SEC rules, you have other rules, you have reporting to the government and to the state for large companies. This FTC rule actually does the opposite. It focuses on small companies. And so, if you're a monster-sized company with lots and lots of employees and lots of revenue, these new rules will not really apply. But if you've got a small company, you're probably going to be caught by this, or at least you have to think about it. And David, my understanding is that in addition to not being enforceable, the Federal Trade Commission can actually come in and impose penalties. And also the company might suffer reputational loss by having very great restrictions on people who work there.
Yes, that's correct. There is a setup for fines, different penalties for violation, as well as the fact that, of course, it can't be enforced. So that's something to consider too. It's not, if you have something there in place, it's not just that you're not going to be able to enforce it. It's that you could face penalties from the FTC for having put that in there.
Marty, you're
David,
muted.
one of the things that concerns a lot of our closely held businesses, a lot of our clients, you can't hear me?
Now we can, Marty. Now we
Can you hear me okay?
Yep.
Now we can.
Sorry about that. One of the things that concerns a lot of our clients, a lot of them are very private, which is why the Corporate Transparency Act is going to really upset them when they realize what's going on. But one of the things that concern me about this FTC, and I'm asking you as a question because I have no familiarity with this, the FTC, if they come after a company because the company has had inappropriate non-competes and the FTC sanctions them, fines them, could that not lead to some publicity? Maybe even the FTC wants that in order to get the word out that you got to take this seriously. That could make closely held businesses uncomfortable, or worse, even have reputation damage to their business. Is that possible?
Yeah, I would say certainly, and then I think Jonathan was just mentioning that also. And yeah, if it could get very public, I could see, and it's not a good look to be putting what are now essentially illegal non-compete restrictions on your entire employee base and trying to get away with that. It's not going to look good for a company if the FTC determines that they're violating those rules and it gets out there in the news. We'd see it probably be on a case-by-case basis, I'd imagine, but I could see it hurting some companies' ability to attract employees, especially top-level employees.
But let me mention that, again, this rule applies to all companies, whether they're big or whether they're small. So if you work for a large manufacturing company and you want to go and work for that company's major competitor, you would be restricted. They'd say, well, you can't do it certain areas or maybe the entire world, and you can't do it during a certain period of time. But that's now changed. Now it can't be done generally at all. You can still have certain non-disclosure agreements, and you can protect yourself or your company for patent infringement. That's always been the case. But if you're just, you're a worker and you've been working there, and your company says, hey, if you go work for one of our competitors, that will hurt us, which may well be true. But this prevents that from happening. Now, there are institutions and individual companies which are fighting this. They feel it's unfair. But keep in mind that what the FTC is trying to do is to generate competition, because competition basically reduces the cost of goods and services. And if you have something where it's basically you're a large company, you control a big part of the market, and you basically say, hey, if you've worked here, you can't work for one of our competitors or start a competing business, that's going to really stifle competition, which is not good for the economy. In fact, when you look at it back historically, two of the big things that really happened, which helped the economy, was one, the deregulation of the airline industry. And I won't give you a lot of background, but up until Jimmy Carter got that through, it was very tough to get a decent priced flight almost anywhere in the United States. And there were hundreds of small communities, which the airlines just said, because it was all regulated, we're not going to bother because we can't make enough money. So that was one of the things that happened. The other one, which affects us all today, is the monopoly that AT&T had for telephones. When I was younger, Marty, maybe even you're younger, David, I don't think you were, you couldn't even legally own a telephone. You had to rent it from AT&T. And I can remember when I was in college, if I wanted to call home for just 3 minutes, and this was in the mid 1960s, it was $8. It would be like, a couple of $100 now to make a 3-minute telephone call. But a judge in Texas, federal judge, determined that that was unlawful monopolization, and he said you couldn't do it anymore. And that's why essentially today you can make free telephone calls. So what the FTC is trying to do is to just increase competition. And yes, that will certainly hurt businesses which have a product or a construction of things that they basically have the equivalent of a monopoly because they're prohibiting their former employees from going ahead and competing. But Marty, let's get into some of the rules if we could.
No, before we do that, let's one topic before that, because the rules are fascinating, and everything that David and Jonathan were saying, we have to dig in a little deeper, and we will give you materials, and the PowerPoint will have more than we'll ever cover in the hour that we have.
Let me say this is something that's going to hit home whenever you represent, for example, a closely held business. You've got a closely held business and you want to do a number of things. Typically, you want it to survive, whether it's going to be sold or be taken over by some of your descendants or other people who are there. And you're really trying to do that. And you want your workers not to be able to go out and basically form competing companies. So even if they're family members, you might say, well, I don't want my oldest son going off and starting a competing business. I mean, he's been working here since he was, say, 16 years old. He's now 35, and he's got disagreements with you, and he thinks he can do a better job. So he goes ahead and he forms a competing business. What the owner would do to try to prevent that from happening is he would put restrictions on it. He'd say, you can't do that. You've got to wait 2 years or 5 years, whatever it might be. And by the way, that varies tremendously from a historic perspective, from jurisdiction to jurisdiction. So he would go ahead and put that in there. Well, if you've got restrictions in a business and the business is trying to basically stifle competition, that business may well be worth more. So the fundamental thing to think about with your clients is, geez, not only do we have to comply with these rules, that we can't go to our workers and say, you've all got to sign not competes. And this may not just be the highest level people in the company, but almost anybody who's worked there. They just don't want them going out to competitors and trying to get more competition, which would perhaps reduce the amount of business which the company, which is owned by the family, has. But they're going to do it and try to do it right from the inception. Well, that will increase the value of the business if they can do it. But now if you have these restrictions on being able to stop competition, that may reduce the value of the business. And that's something that you really need to talk to your clients about. Number one, maybe this helps from an estate planning perspective because we can't stifle competition. That means that the business may be worth less. But from an estate planning perspective, maybe you don't want that to happen. You want it to be basically a restricted kind of industry there. So you've got to balance that, but it's certainly something that you need to take into account, especially when you go to an appraiser and say, we want to give interest in this company. And, you want to talk to the appraiser. Just don't look at our past 5 years of income and gain and dividends that we paid or distributions if it's a partnership or a proprietorship, but also take a look at how this will affect our business going forward. whether or not it's going to make the industry more competitive, so it will cause us to maybe go out of business. I mean, one of the things that happened, and you can take a look, there used to be a book that was out called Thomas's Guide, which had books which would list certain things that were sold in the marketplace, whether those were commercial stoves, whether they were, jet skis, no matter what it was, you could go in there and find them. Well, that was a great business, but all of a sudden came along the internet. And the internet meant that you didn't have to go to Thomas's Guide to get people to look at your stuff. You just had to put up your own website. And the internet has caused tremendous competition, which has reduced the cost of goods in general. And that's one of the things that you have to think about. So it's not just, well, gee, how is this going to work from a perspective of trying to reduce the value? But it may be that these new restrictions where you can't have competition are actually going to reduce the value of the business. And that's something that you need to talk to an appraiser about. So if you have someone, say, who is in, say, has a hamburger chain in your location, and you have forbidden anybody from the people who are out front talking to the customers to those flipping burgers in the back, if they can't go work for a competitor, and believe it or not, it's my understanding that even in that industry, there are non-competition agreements. Even though I wouldn't say those people who flip the burgers are highly skilled, you can really reduce the competition. But if that's gone, so now another competitor can come in and go to your employees and say, hey, I know you flip burgers greater than anybody in this county. Come work for me. Well, that may really reduce the amount of value of that business. Have you had experience with that, David?
Not necessarily in that exact example, but yes, I think you're 100% correct that the use of these non-competes was very, very widespread. I think it kind of just became a template part of the form of any employee that a company would hire. Just put it in there, and it definitely has a stifling effect on competition. And I think that is really one of the big reasons that the FTC really started looking at this. Was there was maybe a little overzealousness with the use of restrictive covenants and non-competes particularly, and not just focused on higher level, larger earning employees, but also even for people working on the grill at a fast food restaurant or a teller at a bank. I mean, you might be surprised, but you could often find these covenants, these non-competes in their agreements.
Let me interject a couple of comments on estate planning, then we'll get into the rules. I cut my camera off because I think it helped the bandwidth. You can hear me okay now, yes?
Yes.
Oh, yes.
So just let me recap a couple of things Jonathan said, and then let's dig into the rules. I think estate planners need to understand this, at least big picture, and they certainly need to keep it top of mind, because we all will be inundated, as Jonathan and I were talking earlier, with planning pre the end of 2025, pre-2026 planning. We're going to see tremendous wealth transfers before the exemption goes down. When those wealth transfers include interest in closely held businesses, as Jonathan explained, it could impact the value. Sometimes worse, sometimes better, it just depends, but it's something that has to be evaluated in light of this new development. The most significant thing that I think affects our planning for closely held and family businesses and succession planning is not the impact on a value of a business from, say, mid-tier workers like tellers or clerks or mid-level management being restricted, but we'll have to deal with that, but really for the key executives that may help transition a family business. So many of our clients that have family businesses may not have children or other heirs to succeed, or even if they do, the children or other heirs may be too young, or they may not have all the skill sets. So what traditionally many closely held and family businesses tried to do was entice and bind key workers to help with that transition. They can no longer bind them. Now, there is one exception we'll talk about for agreements in place before the effective date. which I think is in August of this year, 120 days after publication in the Federal Register. But this is going to affect in a dramatic way some of our clients' business succession plans. And that to me is one of the key conversations that we as advisors in all the different disciplines need to have with our clients about succession. Let's get into it and start talking about it. And Dave, if you want to lead the charge, that's fine. I think there's a couple of things that need to be done now because you can still get senior executives tied in before the effective date, and I think you have to give notice before the effective date. Maybe you want to chat for a minute about some of the more important current steps people need to think about and advise clients about.
Sure. So yeah, those two items that you just mentioned are things that you might want to think about. Definitely. The first one I'll just mention is the notice requirement that you were getting at. That's part of the new rule, is that you're required to give notice to your current employees who have these non-competes already in their agreements, that you're required to give them notice, clear notice that non-compete cannot and will not be enforced against them. So that's a requirement of the rule.
David, would that also be true for someone who has left the business but is still under the threat of a non-compete?
Yeah, they don't carve that out. So they really don't carve anything out specifically. So practically speaking, there could be, well, let me correct myself. They do carve one thing out, is that they do address if you just don't know where someone is located, if you can't possibly find them, there is some leniency for that, but there's no date cutoff. It's not just for current employees. It's everyone, and anyone you have this provision is still effective. You are supposed to give them this notice. So it could be a lot to look through.
Dave, we have a detailed discussion later if we get to it. The key point here is just to highlight that action is necessary on this law today. You cannot wait for the effective date. I know there have already been court challenges against the FTC's action, but you really can't wait. So that's kind of what I wanted you to emphasize now. What do people need to think about, and why can't they wait? And then we'll get to some more details later.
So there's that one. So you have to give that notice. But then if you have any key employees in place at the moment who would fit the definition in the rule as senior executives, and for some reason you don't have any of these restrictions in place with them, you want to consider if you want to get them, or see if you can get them in place now, because they'll get grandfathered in. So those can still be effective going in for those particular workers who meet that definition. But once the effective date comes, then it's too late. You can't put a non-compete on anyone, even senior executives, after the effective date has already passed.
So that's a take-home point from this slide. We're going to go through, if we have time, in more detail what a senior executive is and that exception, and there's a couple of other very limited exceptions. We're going to talk about them, and it's in the materials, and we're going to talk in detail, if we have time, about the notice provisions. The key point is you as an advisor have to tell, or should tell, your clients, hey, you may want to take action now. What David just explained, that you could still get a non-compete in place if somebody meets a requirement of senior executive, which we'll go through that definition later. You need to act now. So this is something that you can't wait to see what happens with court cases, because if it's upheld the way it is now, you will lose, your clients could lose out on valuable current opportunities. David, I think,
But
go on,
Marty, let me add that let's say you have some people in your company that you believe would be senior executives, and that's a very, very small group of people. It's not just because you made important decisions or you were, labeled as a vice president or something. It's very, very restricted who is a senior executive. But let's say you've got somebody that you feel is a senior executive and you want to now restrict them. You want them to enter into a non-competition agreement where there is one before. Well, I've got to tell you, if one of those people called me and I was his or her lawyer, I would say, don't sign it. Just wait them out. Presumably, they regard you as very valuable, and you're now in a position to negotiate a much better deal. Maybe getting, more equity or a greater percentage of profits, or getting an interest in profits where you didn't have one before. So I think the notion that, well, we're not going to worry about it because we've got, another 110 days or whatever it is, then we'll just get all these people who are senior executives to agree, and therefore they'll be bound forever. I just don't think it's going to happen. David and Marty are absolutely right. If you have non-competition provisions out there, you must tell these people that they're not bound by it anymore. And I don't know what the FTC is going to do if you fail to do that, but there can be fines, there can be reputation risks. You can imagine a local newspaper, taking your business and saying that they had been using this and now this has basically been declared unlawful. And if you don't tell your folks that they're no longer bound by it, I think that would be a mistake.
David, you talked in the beginning about when I asked you to do just a quick intro to set the stage, because I think a lot of practitioners may have heard nothing about this and know nothing about it. Take a few minutes, and I can advance the slides as you tell me to, and you can ignore the slides if you just want to talk. Just give a little more depth about what a non-competition is, what an NDA is, what a non-solicitation is, and how they relate, and set the stage for the detailed discussion that's coming after this.
Sure. So taking it one at a time, the NDA or confidentiality agreement is essentially let me go in order with the slides here. So I'll start with the non-compete agreement. Would be a covenant that the employee would not work for another person or start their own business, and it's usually written very broadly, so in any capacity, like start new business as an owner, be an employee, be an independent contractor, be a consultant, basically have anything to do with any competing business. And it's often restricted to a geographic area or a time period, although as the world has progressed, and Jonathan brought up the internet before, especially as that has become a thing, people have tried pushing these geographic limitations to include basically anywhere, because a lot of it depends on the type of business, but a lot of them are not really bound to an office building and anymore like they used to be. But anyway, so it just disallows the employee from going and working in a competing business or opening a competing business. To the non-disclosure agreement or confidentiality agreement is aimed at protecting company information. These are usually set up where an employee, and these usually last often forever. Sometimes there are time restrictions, but these more so last longer than the non-compete agreement does. And this restricts the employee's ability to both disclose any confidential information, but also to use it for his or her own benefit. And what exactly is covered by confidential information gets set in the agreement. Obviously, the company likes to be as broad as they possibly can with that. Definitely, it would usually include any proprietary information, any intellectual property. If they have any patents, anything like that is certainly included. Also, a big item is customer lists and contact information for them. That's often very important for companies, that they don't want their employees or anyone to be able to give to someone else or use themselves.
And just so everyone understands, now that non-competition agreements with very limited exceptions for senior executives and sales of business interests that we'll talk about are banned, the first reaction is, okay, I'm going to call my corporate attorney, my employment attorney, David, and I'm going to say, hey, David, we can't do a non-compete, but let's wrap these people up with all the NDAs and non-solicitation agreements. Let's try to do what we can using other mechanisms to restrict them. And the answer is going to be, and it's going to be taking a sort of a very fine-tuned approach to doing it, is you can still try to protect certain rights, but you're going to have to be very, very careful in how you do it. Because, and this is why I wanted David to mention that, and he'll get to a non-solicitation agreement in a second. But the problem is that if the NDA, the non-disclosure, non-solicitation, any other kind of restrictions you have, and I'm not going to use the precise language, you guys can correct me, rise to the level of being equivalent to, or functionally equivalent to, I think maybe the word, of a non-compete, those are banned too. The FTC has taken a very broad approach for the reasons Jonathan explained to promote competition, and you can't just sidestep and change the language and think you're going to still restrict somebody.
Well, let me mention, even in our industry, say in law or our cousin, the accounting industry, where it's very, very frequent to have non-competition things, those are gone. And there's actually a model rule for lawyers, Model Rule 5.6, which prohibits lawyers from trying to use non-competition provisions except in connection with retirement. But if you go back one slide, Marty, I want to point out here, and I think this is kind of important, you'll notice at the bottom it says that an agreement that extinguishes a person's obligation, this would be, say, the law firm or the accounting firm, to provide promised compensation, which could be allegedly retirement pay, or to pay benefits due if the worker seeks or accepts other work or starts a competing business, that probably is void as well. And this would seem to be in contradiction to the exception made in Model Rule 5.6, which says, okay, you can't have non-competition except in connection with retirement. Well, now it appears that you can't even do it in connection with retirement under this FTC rule. So you need, if you're a lawyer or you're an accountant and you have restrictions in your partnership agreement or something else, whether it's for a partner or for an employee or someone else, you better take a look and remember you're going to be required to give notice that they are not bound by this anymore. And if you fail to do it, I think that the FTC may come down pretty hard on you, or a local reporter may say, hey, take a look at what these people are doing. They're bad people. So you get bad reputation consequences as well.
Let me just emphasize what Jonathan just said. Up until Jonathan's recent comment, we've been talking about telling advisors what they want to talk to clients about. Jonathan has just pointed out a really important aspect to this. This is not only about representing our clients, this may have a dramatic impact on a lot of the advisors that are on this call, because your non-compete, or if a colleague of yours retired and can't compete, those provisions may now be void. So this is a significant factor for succession planning for professional practices. And Jonathan, this may be out of place because we have more detail on the senior executive definition later, but because you brought up like accounting firms, if I'm a partner in a 200-person accounting firm, would I qualify as a senior executive? Because I have to have policy-making decision. Would I even be?
Well, the definition of a senior executive is very restricted. It's basically,
Right.
You know, the CEO or maybe the chief financial officer who has the ability to make basically binding decisions that the organization is going to follow. Just because you're a partner in a partnership, like a partner in a medium-sized law firm or accounting firm, I don't think you come close to being a senior executive, because you're not going to be able to make binding rules for that organization. You know, I was a partner at a big law firm, and David, I know yours is not quite as big as Milbank was. And I don't know whether you have these kind of rules, but, you know, I was told I couldn't even somehow fire my secretary. I couldn't pay her a bonus. One time I wanted to give BlackBerries to all of my associates. I was going to pay for it out of my own pocket. And the chairman of the firm said, if you do that, I'll have you fired. So I certainly, even though I was a fairly prominent partner at Milbank, I certainly was not a senior executive. And keep in mind that this is exceptions only for prior agreements. You can't say, well, we're going to go to the CEO right now and get him to sign up. It's not going to happen. He's going to dilly-dally until the time is expired, which was 120 days from when this rule went published, and I can't remember the exact date of when it was published. But basically, by the time we get to September, you can't do it anymore. All of the prior ones will be basically void. And if you try to enforce them, I think you're going to be in deep tapioca with the FTC.
Hey, David, have you had partners at accounting firms calling you? Because I know that that's a common approach in a lot of accounting firms. They have a mandatory retirement age because they want to move older partners out so the younger people can rise to partnership, and they usually have non-competes. Have you had any experience with that or had any calls yet?
I haven't had any calls yet. I mean, that is, as you say, it's a common setup. And I expect it's something that we're going to start getting calls on, or we'll have to start making calls on. Something they're going to have to consider and maybe change the way they're doing things a little. And Jonathan, I've never checked into whether or not I can do any of those things, but I would guess that I cannot, that I do not have the authority to do any of that. And I completely agree with you that just being a partner and
you've got to be, the chair of the firm or the CEO.
Management committee.
I would say we have an executive committee, and I think maybe those couple of people might fit the definition, and that's pretty much.
But perhaps only while they're there. For example, at my firm, people were rolled onto our committee, which had basically the power to make rules, but they would roll off after usually 3 or 4 years, in which case they were no longer bound by it. So they no longer would be a senior executive. And I don't know whether the rule says, well, if you signed it when you were a senior executive, you're still bound, even though you're not a senior executive now. I don't think you are. I think once you're let go from being a member of the big committee at the firm, you're no longer bound by it. But that's something that the firms will have to consider, taking into account that they do not want to flaunt these rules. So one of the things you might think about is do some disclosure to your clients. If you think that they may be covered by this rule, you better warn them, because if they're caught, they're going to be very upset that you didn't warn them that these things were no longer enforceable. Now, they're also going to come back, and David, maybe, well, what do? I don't want all these people flipping hamburgers, in the kitchen to start working for a competitor. What do I do to keep them from going to a competitor or starting a competing hamburger business?
Pay them more.
Yes, that's exactly right, Marty. One of the things you might consider is giving them a percentage of compensation based upon what the company does. Many companies use that as an incentive for people to work hard and to stay with it. But I think even if you say, well, you're going to get a piece of the equity, but only if you're around for a certain period of time. David, do you have a view on that? Suppose I go work for someone. I'm not a senior executive, but it says, okay, you're going to be paid so much money, but we're going to give you a piece of the equity growing over time. But if you leave, you're certainly not going to get the future compensation or percentage of equity. But can they take it away retroactively?
I would say when people set that up, they often set it up with vesting requirements. And I think that would likely still be fine, that if you leave any portion that has not vested yet, it's just taken away. The rest of it, I think maybe you have a buyback arrangement. I would also consider using phantom equity rather than actual equity. You may not want to give these people actual ownership in the company. Instead, you give them phantom equity, which gives them some incentive-based compensation where it essentially pretends that they have equity. As the company makes money and makes distributions, they will get some payment, but they don't actually have any ownership rights.
That's very.
Keep in mind that there is an ongoing exception for the sale of a business. So
let's get to all of that, guys. Let's get to all of that. let's, David or Jonathan, we've talked a lot about senior executives. Now we have the slide on it. David, you want to just fill in the blanks on what this exception is for senior executives? I don't think we need to spend a lot of time because we've kind of covered it.
Yeah,
But
I'll just say it real quick. I mean, we've kind of said it's going to be very few people. There's a dollar threshold, which you can see there on the slide. They have to make more than $151,164. And don't ask me why they came up with that number. There might be something written about it somewhere, but it seems it's a very specific number. So they have to make more than that, and they have to be in a policy-making position, which is not going to be very many people. They have to have the authority to make essentially final decisions that significantly impact the company and its business.
let me just add a quick comment on this point. As Jonathan said, it's not many people. The FTC estimates 1% of employees will qualify as senior executives. Second, as we said earlier, you got to have these in place before the effective date. So if you and your firm or your clients need or want this, they better do it fast because time is running out. But here's another point, and we're going to have, if we get to it, and if not, there's slides on the notice provisions. I think before you send a notice to an employee saying you're not bound by the non-compete, you better make sure that that person did not qualify as a senior executive. You don't want to give notice to somebody saying the non-compete in your employment agreement or the shareholders agreement is no longer binding, and oh gee, they were somebody that was a senior executive and you could have let them be bound. So you can't just send these notices out without thinking about them for sure. David, the other topic, and you, Jonathan, and I spent probably a half an hour talking about just this preparing. We probably only should spend a couple of minutes, but give some guidance on what we can still do to protect ourselves and how it's not unlimited, because if it arises to the level or is a functional equivalent of a non-compete, we're going to be hammered by the new law.
Yes, right. Yeah. So the other items that we talked about, the other types of restrictions, NDAs, confidentiality, non-solicitation agreements, they have not been made per se unlawful by this new final rule. The final rule focuses on the non-compete restrictions. So you could potentially still include some confidentiality and non-solicitation covenants in employment agreements or stockholder agreements, et cetera. The issue is that it cannot be so great that it has the functional effect as a non-compete provision. That's the discussion that they have in the final rules. They do mention that it's possible to have less restrictive provisions than a non-compete, such as these other items to protect your business, but it cannot be so overbroad and onerous as to functionally be the same as a non-compete provision. And that's going to be a facts and circumstances test. So there's not a ton of guidance on exactly where the line is going to be drawn at this time, but that's something that everyone would have to consider and try to get comfortable with protecting their business as much as you can, but not crossing the line.
Let me just emphasize one of the many comments from the conversation we had preparing for this. You have to really look at each individual situation. So if you have two employees and one's in a large metropolitan area, one's in a rural area, the answers may be very different, because in a large metropolitan area, the person may be able to go out even subject to those restrictions and find new employment or start a business. In a more rural area, it may not be possible. You have to look at the nature of the business, the nature of the restrictions. And I think one of the things, and I don't remember if it was in the FTC materials or that David suggested, but an important point, you want to not only try to be reasonable, but the less broad, the more specific your restrictions, perhaps the more likely they will be to be withheld, to stand up. But this requires that a lot of our client businesses and a lot of our practices need to really rethink all the things that have been done before. Family dynamics, Jonathan, we had talked a little about that. You may want to think before hiring that son-in-law in the business, because you can't restrict him. If there's a divorce, he leaves and goes to the competitor. Any comments on that?
Well, I mean, that's true. I mean, one of the things, and I have not been 100% successful, is telling my clients, don't hire in-laws. Marty and David, I don't know if you two know the difference between in-laws and outlaws. Outlaws are wanted, and figuring that half of marriages in the United States end in divorce. You don't want your son-in-law or daughter-in-law to be in a position of that. So, and trying to get rid of them is, in a divorce, it's going to be so difficult, so nasty, that you just don't want that. So my advice is always don't hire your son-in-law, don't hire your daughter-in-law, don't give them equity in it. Give it to your child or your grandchild, who can then create a trust for the benefit of their spouse, if that makes sense and everything is working well. But that's really something you have to consider. Who are the players on this?
And even for siblings themselves, if there's a falling out between siblings in a family business, and one of them says, you know what, I don't want to work with you anymore, I'm going down the block and opening a competing business, you can't stop them like you may have before. So the non-competes can't be the glue to hold the family together. So this is going to affect the succession planning we talk to clients about. David, there's an exception for the sale of a business. Do you want to comment on that?
Yes, so this, and they initially had some limitations that ended up getting removed. So it's became a pretty simple exception, actually. If you own a business, and then whether you sell the equity or whether the company sells its assets, whatever form of sale you take, the buyer is able to put a non-compete on the seller or sellers in connection with that sale. I see it's mentioned on the slide here. Initially, it required you could only restrict sellers who had at least a 25% ownership interest. That limitation was removed. So any seller of the business, they can have a non-compete put on them, which I was happy to see this exception. I mean, I can understand the logic of what the FTC is doing in certain employment situations. But I thought it was going to make it very difficult to sell a business if you couldn't put non-competes on the seller, because it'd be very difficult for a buyer to come spend a lot of money and buy the business if the seller could just open up the exact same business right next door a week later. And so to Jonathan's point a lot earlier about effects on value, because you can't put non-competes on employees, it might hurt the value. This just proves that. I think if this exception wasn't here, values of businesses would have definitely dropped, because who's going to pay top dollar for a business when you might just end up competing with the person who sold it to you?
Well, that's true. And keep in mind that very often, like in professional firms, you may have restrictions on people who leave the business, but they're usually not styled as true sale of the business. Someone might say, well, you were entitled to 10% of the profits in a particular, let's say, an accounting firm, and you want to leave, and are they going to say, no, we can have a non-competition agreement with you because you're a 10% owner? Well, they're not really an owner. They can't sell it to someone else. So one of the things I hope that will ultimately get clarified is, does it really mean equity as we traditionally know it, as opposed to something in a professional firm where you really get 10% of the profits, but you don't own 10% of the company?
Yeah, that's a good point. I think this is clearly aimed at an actual sale of a business, where someone owns a manufacturing plant or something, and they sell 100% of the equity in it to a third party. So I could certainly see people trying to use it in the case of buying out a quote 10% equity partner, but I think this is aimed toward, really, they use the word bona fide. I think that it's aimed towards a real sale of a business.
I think, just to emphasize the point David made, when I first read the exception, I said, oh, great, we'll give everybody 0.1% non-voting equity and then slap them with the non-compete when they leave. But David just used one of the key phrases. The FTC's rule makes it very clear it's got to be a real bona fide sale. You can't just concoct a purported sale in order to slap a non-compete on someone. It's not going to work. David, we've talked about the notice provisions. Is there anything we need to add to that? And there is more material in the slides, folks, than we're going to get to. But do you want to add anything to the notice provisions other than?
I don't think we covered it. I don't know that there's anything to add. It just has to be a very clear, conspicuous notice.
We'll better start looking at this stuff now.
Excuse me? What was that, Marty?
David, do you want to add anything more?
Oh, no.
I didn't say
no,
anything.
I think we covered
You want to
that.
add anything on notice provisions? Okay, just keep in mind, logistically, this may not be simple. If you don't have everything digitized and OCR'd, you may have to go back to old personnel files to find the information. It may be quite a burdensome task. What happens, David, if you don't comply? What happens to the bad people?
Well, there is no private cause of action, so it would be an FTC enforcement action. First of all, your non-compete or your other covenants that rise to that level would not be enforceable, so you're not going to be able to enforce it. There's also could be penalties levied by the FTC against you, and I think that there's a chance you may also be, and in some cases have to pay compensation to the employee if there was some damage there. But it's not a private cause of action, though. The employees are not going to be able to start lawsuits against the employers. I think they're going to have I don't know exactly how they're going to do it, but they'll have a way for people to report suspected violations to the FTC, and then the FTC will make the decision of what they're going to go after.
David, would somebody that feels aggrieved rat on their employer to the FTC? Is that a way an employee that feels their employer is trying to enforce unreasonable restrictions? Is that something that could be feasible?
Oh, I couldn't imagine. No, yeah, absolutely. I in fact, even an employee who's not actually aggrieved, I could see reporting something.
So to wrap up, we've actually gotten through all the topics. Jonathan, you want to make some concluding remarks, and then David, then I will.
Well, Marty, all I'm going to say is I think that this is very important. In general, if you represent owners of closely held businesses, or maybe even you represent big companies, this is something that has to be considered. On estate planning per se, as we've discussed, it is going to affect valuation. And if you're in the middle of doing a valuation report, you need to consider how this is going to affect it and tell your appraiser to take that into account in valuing the company.
David, any comments to conclude?
Yeah, I'll just conclude by saying that this is certainly anyone who has a company with employees, this is going to have an impact. And it's something that you have to look at, but you have to look at now. As we went through this, you really can't wait, because you want to make sure you can deal with it in the next 120, whatever exactly days it is, before it becomes effective, both to give the notice, to maybe get any agreements that will be grandfathered in place, and also to consider how you're going to deal going forward after this becomes effective, so that you don't have issues that come up with employees leaving and trying to start competing businesses.
It seems to me that the FTC is pretty clear that they want to quash the use of restrictive agreements, especially non-competes or things that arise to that level, the functional equivalence of it. I don't think there's going to be a lot of room to maneuver around those. I think it's just going to be the new environment we have to deal with, just like Jonathan explained, deregulation of phone company and airlines. I mean, now this is just going to become a fact of life, but it's going to require that we help guide clients and our own practices to navigate the new environment. And just, as a practitioner, we just got 500 and something pages of information from the FinCEN on the Corporate Transparency Act. I think the FTC rule and preamble and discussions is over 500 pages. There are just new regulations on GST allocations. We got 2026, pre-2026 planning coming down the pike. Maybe we should all invest in, coffee companies, because I think we're all going to be drinking a lot of coffee to get through what is coming down here. I wish everybody good luck, and I thank Jonathan and David for their. It is my fault, and I apologize for some of the internet connectivity. I'm actually on vacation, so forgive me. I was just trying to get this done quickly because I think it's so very important, and I appreciate your patience with some of the technical issues, but hopefully we've gotten you some good information that you can use right away. Thank you, everybody, for joining.